Tuesday Law and Tech series for the year. And I couldn't be happier to begin with Nikolas Guggenberger, who is assistant professor of law at University of Houston Law Center, but was also my predecessor and executive director of the Information Society Project. So unsurprisingly, has a full house. Nick, thank you for doing this. We look forward to it.
Well, thank you so much for having me, and thank you so much for skipping Barack Obama's lecture next door and choosing this over him. I'm honored. I'm honored. I know that you all have other opportunities. So this project is about properties functions and how online, meaning in platform markets specifically, properties functions have turned against each other. By the way, how long do you want me to talk?
And then we have until 1:25.
50 minutes. I'm mostly interested in your comments on this project, not so much in hearing myself talk, but I'll stretch it out a bit. Okay, so this project is about properties functions turning against each other in the online sphere, specifically as it relates to platform markets. More specifically, the project is about how internalization, the internalization of externalities, is so successful in platform markets that it crowds out, that it pushes out, that it undermines two of the other essential functions that property regimes usually fulfill, that is to create modularity and to promote liberty. From that, I hope to be making two main contributions. The first main contribution is one that's very much in the tradition of political economy analyses, that is to say that online market concentration is primarily a function of property design. It's another way of saying law shapes the market structure that we see online. And this first one, this is really intended to be a response to accounts that blame, well, economic realities, or that is not legally created economic realities, but natural economic realities as the source of online concentration. And the second one, that is a sort of a normative conclusion from the argument, that is to say that if we really want to realize property's full potential, that is, if we want to realize all of property's functions, then we potentially counterintuitively have to scale back one of its main functions, namely the internalization of externalities, because momentarily that is what crowds out, that is what undermines property's other essential functions, being the creation of modularity and liberty. So with that said, I want to walk through 4 steps here. First, I want to talk a bit, this is sort of an extended intro, about properties functions generally speaking, then move to network enclosure, 5 layers of network enclosure that I think create something like platform property, now not capital P property as in constitutionally protected property, but a regime that functions as a property regime. Third, I want to draw a connection, a straight line from this property regime to the market structure that we see online. And 4, talk a bit how that property regime online works in a way that undermines its own functions, its own goals. So what is property? Well, age-old question. I won't be able to answer it, but there is something at the core of property regimes, and that is an exclusionary function.
But there are different views out there on relating to the extent to which a property exclusionary function is central to property regimes, essential to calling something property. And I think this might find out.
So I'm not sure whether, can people online still hear me? Okay. Apologies for that. But let me restart. So the question, the age-old question is, to what extent property regimes require an exclusionary element? I think what most people agree upon that is that property regimes typically have an exclusionary element. And the controversy, the argument is really only about the extent to which the exclusionary element is necessary is a conditio sine qua non for a property regime, for the recognition of something as property. Now, for my argument here, I don't think I need to decide which one it is. To me, it is clear that if something has an exclusionary function, that is typically something that we call a property regime, and coming from the other direction, the exclusionary function is so central that it is rare to recognize something as property if it does not have an exclusionary function at all. To go into slightly more detail, when people conceptualize property as this right to exclude, then they sometimes focus on this right, meaning, do I have the right to keep others out, to tell others to get off my lawn? Or is it actually a duty that is placed upon the skateboarder here to exclude themselves? The better explanation, and the explanation that matches my argument better, is probably the one of understanding property at its core as a regime that places duties upon others to exclude them from the premises of the owner. So with that said, let's go to what property's exclusionary function does, what it is there for, beyond just dividing the world into mine and yours. So first, what's generally ascribed to property's exclusionary function is the internalization of externalities. If you plant crops, you should be the one who gets those crops. That's what incentivizes you to plant crops, or here, lettuce next year, right? The internalization. We can internalize negative externalities and positive externalities. Positive externalities, the salad, the crop, you should gain the fruits of your labor that you put into your property. Negative externalities, you should bear the costs to the largest extent possible that your behavior on your property causes. So if we find ways to internalize pollution, the argument generally goes, that's what we should normatively do, and practically that's what property regimes can achieve. Second, property is, or an essential function of property is to create modularity. That is to make the world simpler, to break this complex, complicated world down into manageable chunks, into pieces that we can interact with without having to worry about the system as a whole. I can very easily know or infer what kind of rights I have as it relates to some field out there. The most basic thing, I need to stay out if it's not mine. I don't have to understand all of the contractual relationships that the owner entered into with, say, a third party. Property, that is to say, property has the function to simplify the world, to make it conducive for us as simple minds, right? That is one of the property's core functions. What scholars that emphasize this function point out is they say this is what at its core supports property's function in enabling decentralized information aggregation at the market level. Third, property is deemed to be essential, at least by some, to ensuring liberty. Liberty by enabling individual control over resources and by protecting reliance interests from arbitrary state interference. Those are the three essential functions. Now, what do I mean by essential? Well, I mean that they're very hard to achieve without property in a positive transaction world. If we lived in a zero transaction cost world, we could achieve all of that through contracting. What property does is, in a positive transaction cost world, it makes these things possible. And without property, it'd be very, very hard to achieve them. Now, some commentators go further and say that property's essential functions are what enable markets more generally, markets to function. That is to say, to enable decentralized information aggregation throughout the economy. And others go even yet further and say what this enables is democracy as such. Why? Because it ensures the necessary level of liberty. And again, it contributes to decentralized information aggregation. It creates positions in which we are not dependent on others, but can act independently. Property rights can be structured and protected in different ways. The most commonly known distinction as to how we can protect property rights is a distinction between inalienability, property and liability rules on the one axis, and then on the other axis, that is the structure that property rights can be expressed in. They can be expressed in as exclusivity rights, and they can be expressed in by defining governance rules. The first, exclusivity, is a very, very sort of crude notion of you need to stay out, it's mine. Governance structures, property rights that are structured as governance by using governance tools are much more complicated. They would, in the property right, include precise granular descriptions of what you're allowed to do and what you're not allowed to do. Now, on the basis of this, let's switch to platforms. So what do sheep have to do with platforms? Well, my argument is that what happened to digital platforms online is very much comparable to the enclosure movement, in England, where law, among others, among fences, but law transformed common spaces into private property. What we have in the digital sphere is at least 5 layers. 5 layers of enclosure, 5 layers of legal fencing around digital platforms that support this duty that others, that establish that duty upon others to exclude themselves from my platform, or if you want to understand it from the perspective of the owner, that is what supports the owner's right to exclude others, to keep others out. So what are these 5 layers? Well, first, there's a layer of contracts. Contracts that might now sound counterintuitive. Why do I mention contracts as an element of a property regime? Well, for that to make sense, I think we have to let go of this ideal version of how we conclude contracts as individual relationships supported by meaningful consent. And we have to really grapple with how contracts are formed on the basis of the acceptance of terms of service online. And there are at least two things that are distinct. One is that there is an absolutely minimal threshold for consent. That means that a platform can bind you contractually by you simply pinging the server. That a platform might be able to bind you by you continuing to use the services. Things that we generally not allow in the traditional way of how contracts form. This is a sort of a newer mass commerce form of contracting. And in a sense, that means that we implicitly bestow some sort of right on the platform. Why? Well, that looks very similar to you having a property, putting up a sign and saying, if you step on here, you need to follow the following rules. If we don't have any meaningful level of consent to support the binding of our future selves, if that is completely lacking, then we have to have pre-allocated something. And that's something that looks kind of like property. The second layer of legal fencing around platforms is our traditional IP rights, and maybe patents stick out most. This is the patent that that Google originally obtained. This is about the sorting of the algorithm that sorts and indexes websites. And the argument here is not that there's an intellectual property right in platforms. The argument is that at the core of many of those platforms sit intellectual property rights, which are being leveraged to protect the platform as a whole, and again, to exclude others from using core functionalities of that platform. One can extend that to the points where platforms exchange information with potentially with competitors, potentially with users. And again, we have the situation where IP rights sit at the core of sealing the platform off against others, whether it's intruders or whether that is competitors that would like to interconnect. The third layer of platform property-like protection stems from the CFAA. That's the Computer Fraud and Abuse Act, and that basically is a law against hacking, but over time has been extended and has been leveraged to try to prevent things like scraping, that is the gathering of information from websites, and has really been turned into yet another layer of excluding others. Over the last couple of years, the courts have reined in the reach of the CFAA to some extent, but it is unclear. It is unclear to what extent platforms can, one, find ways around that reining in, and two, to what extent the combination of the CFAA and terms of service might still be leveraged to achieve basically the same, namely that is to keep others out. Then there are privacy regimes in the US emerging at the state level, some privacy regimes at the federal level, and of course international privacy regimes like the one, most prominently probably the one in the EU. Many of those, basically all of those privacy regimes have some control-based element to them. And that control-based element is usually understood not as a property right of the platform, but as something akin to a property right of the individual. Akin to, not saying this is a property right, akin to a property right of the individual. So how does this create property-like protection for platforms? Well, at the second level it does, because once you have signed over your privacy rights to the platform now has property-like protections against the rest of the world. The platform has entered into some sort of data relation with you, but at the same time now, that data relation with you is sealed off as it relates to the rest of the world, that is namely competitors. Finally, there is Section 230, usually understood as a liability shield. But what Section 230 also does is it enables limitless internal governance. What does that remind us of? Well, that is, again, what property does usually. It allows you to govern your own spaces according to the rules that you want to set without external pressures. On top of that, if we apply the general Calabresi-Melamed quadrant to Section 230, we will likely conclude that this is a property right, a property right protected by a property rule to pollute the world. This is exactly, Section 230 is the complete insulation from any consequences. A complete insulation from any consequences under this general framework would be a property rule protecting a property right. So with those 5 layers, at least 5 layers of property-like protection, platforms have become experts, are organizational entities that are optimized to do one thing, and that is to internalize externalities. What I put up is the classic essay by Harold Demsetz, in which he describes the primary function of property regimes is to internalize externalities. To what extent? To the extent that boundary drawing is efficient. To the extent that boundary drawing is less expensive, is cheaper than the externalities that are being internalized. And so on this basis, what are platforms? Platforms are organizational entities that are optimized to internalizing externalities. What creates a platform? Law creates a platform as an entity that internalizes externalities. So what are these externalities that a platform internalizes? Positive externalities mostly, positive externalities in the form of network effects. And that core part is what draws the straight line between platform enclosure and platform monopoly. So just very briefly, this is how network effects are usually explained. Network effects scale supralinearly. That means that if you increase the number of nodes of participants in a system, then the number of potential connections that form the basis for communication or transaction increase supralinearly. Nobody has really fully settled on what the exact formula is. Some have just looked at the direct connections and have said that something like n squared minus n divided by 2 estimates the potential connections that are formed. Others have said, well, yes, but there are also subgroups that platforms can form. So think of like Facebook groups or like the possibility of WhatsApp to connect you and me, but also to create new groups among each other. And if you recognize those, then you get a formula that's 2 to the n minus 1. The point is not to inquire what the exact formula here is. The point is that this utility curve is so extremely steep. So if you plug in a number of 100 and apply this formula that recognizes potential subgroups, you're already reaching a number with 30 zeros. Nonillion, apparently. Had to look it up. Nonillion, apparently. The point now, again, is not that this describes exactly the utility curve. If only platforms can internalize a small, tiny fraction of those potential externalities, the curve is still incredibly steep. And so, as some people have wondered whether property is something like monopoly already, because it has this exclusive character, because it allows some owners to charge monopoly rents. It is really this supralinear relationship between size and utility that turns property into monopoly. And note these assertions about, well, it is network effects that create digital monopolies. That is just incomplete. That was one of the motivations that I had to write this piece. It is not network effects. It's the question of how we distribute these network effects and to whom we allocate them. If we allocate them to an individual platform, well, yes, then we can draw a straight line between that allocation and the future monopoly. If we allocate this enormous utility and value to the level of the market, well, then the market might flourish, but not the individual platform. If we assign this, the value, the utility that's being created to society, well, yet a different result will come from that. And just contrast how platforms work to how other open networks work. We all speak English. That's a network. Right? To whom do the benefits of the English network, of the English language accrue? Well, to everybody who is willing and able to speak English. Now, some people might get more out of it. I don't know, because they're famous pundits and have a huge audience. Some people might get less out of it because nobody's interested in listening to them. But the bottom line is everybody can participate. There is nobody who's able to exclude individuals on the basis of a property right from participating in the English language. Small exceptions, trademarks, copyright to some extent, but generally speaking, there is no exclusion. And because there's no exclusion, the network effects that the English language produces does not accrue with a single player, not even just with a few players, but is broadly spread. So there's one side of the story, which I just mentioned, that is to say that there's a property regime that allocates the value of networks to individual platforms. That's not necessarily the end of the story, because we could allocate things and then reallocate things away, just like the tax system does. So it allows people to make money, quite a lot of money, and then it redistributes some of that wealth. It would be possible to have a somewhat similar regime. We could say, well, all those network effects get allocated to an individual platform, and then we have some redistribution mechanism. The problem is we don't. And two things stand out. Internet policy from the very beginning, when it became a distinct thing, that is probably in the 1990s, has just not recognized this inherent tendency to establish monopolies if and when we recognize property rights. We can go back famously to the Clinton administration's framework on e-commerce. They see monopolies at the edges, at the level of the physical infrastructure, for example. They do not even contemplate that we might have online monopolies. For a very long time, the mantra was that competition is one click away. Well, competition has interestingly kept one click away, stayed one click away for now 30 years approximately. For some platforms, it's only been 20 years. That is to say, there is just no meaningful regulatory check on this allocation. Second, antitrust specifically has, one, just not been enforced for a very, very long time, basically the entire existence of the commercial internet until very, very recently. And second, even to the extent where antitrust is enforced. So, for example, recently a court has found that Google is operating two illegal monopolies, one in search, one in advertising. We got the remedies ruling very recently on the search part, and the remedies are basically a joke. So even where antitrust finds a monopoly, and in parentheses, it usually doesn't, an illegal monopoly, even then it doesn't create the appropriate remedies to redistribute network effects in a way that would reestablish competition. Third, these property-like entitlements, they don't just allocate the value, the worth, the utility of the networks to the individual platform, they also entrench it. They entrench it, one, by means of just making them durable, right? If you give them property-like character, they become more durable. But also because many of those property-like entitlements, they're worth more to the incumbent than they are to the nascent competition. They're worth more to the big player than they are to the small player. The ability to more or less legislate by means of contract, by means of terms of service, that is worth much more if you own half the market than if you're a small competitor. Section 230, that's oftentimes heralded as this pro-competitive rule that allows small players to be shielded and guarded from defamation suits. Well, that in itself is worth much more to Facebook than it is to the tiny competitor. Why? Well, defamation suits are uncapped. So they are capped, factually capped for the small competitor, namely by market value. So if you have a small startup worth $3 million, the most that a defamation lawsuit can do to you is $3 million. If you're Fox News sized, then it might, and a digital platform, then it might shield you from something like, what was it, $760 million, which was the worth of the settlement that Fox News had engaged with. Fox News, of course, in that instance, not being shielded by Section 230. So what does all this do? My point is, all this excessive internalization of externalities systemically creates concentration online, underwrites monopolies in their existence. And by means of concentrating the market structure, it first undermines modularity. Remember the transparent car earlier, where you see the individual parts, where you can interact with the individual parts, where you might be able to repair the motor without having to worry about the wheels, where you can change the wheels without having to worry about the muffler, where you can interact with individual parts, where things become simple because you don't have to understand the whole thing. Well, that completely changes in a monopolized structure. All of a sudden, you have this one big player that offers you a package. The world is no longer broken down in small individual pieces. The world is not made simpler. The world is now as complex as the world is. Property loses its function to simplify the world. The second part is that the excessive internalization of externalities undermines liberty. It turns the ability to control resources individually in a discrete manner from others into economic dependency. If you want to start any business today, you depend on the app stores. There's just simply no way around the app stores. You depend on them. And depending on how you construct the market, we have either a duopoly or a monopoly. If you want to engage in advertisement, I don't know how you're going to get around Google and or Facebook. There is just no way. That is to say that the excessive internalization of network externalities by creating a concentrated market structure undermines property's third and maybe arguably most important function, that is to enable liberty. Both the undermining of modularity as well as the undermining of liberty has systemic consequences. Systemic consequence one is that it messes with the market's ability to aggregate, to engage in decentralized aggregation of information. It just is in stark contrast to this machine that Hayek imagined, this machine that replaces planning. Second, it messes with functioning democracy. It messes with functioning democracy in several ways. One, the economic dependency that monopolies create are just incompatible with any notion of democratic self-governance. The person who has probably best expressed that thought might be Thurman Arnold in some publications in the 1930s, where he says that monopoly power might be power that's levied beneficially, but at the end of the day, it remains dictatorial power. There is just no other way to understand monopoly power than enabling the individual to act independently from any sort of market check. Second, it enables oligarchy. It enables oligarchy in ways that might have become apparent more recently, and it enables oligarchy also at a sort of theoretical, systematic level. First, it gives individual players outsized influence. Outsized influence to access, well, the polity that's supposed to self-deliberate. If you think about how the TikTok ban played out, what did TikTok do? Well, it didn't engage in like traditional lobbying. Well, it also did, but actually very unsuccessfully. What was much more successful? Well, it had millions of connections to individuals. It just sent out a push message telling everyone that tomorrow things are going to be shut down. That's what has the most impact. The impact of that single action eclipsed the effectiveness of basically all types of lobbying that we've ever seen. So direct. And it wasn't even targeted. They just sent out a message to everyone, and it worked. It worked with fantastic efficiency. Second, it changes the incentives, the incentive structures around traditional lobbying. So that sort of very old public choice analysis is to say, in a competitive market, a very small percentage of your lobbying expenses are worth it. Why? Well, because you're sharing most of it with industry competitors.
if I'm able to get favorable regulatory treatment, most of that benefit in a competitive market will accrue to my competitors. They will benefit just as much as I will, or likely in the aggregate more. If you're a monopolist, or if the market is concentrated, that calculation changes. All of a sudden, lobbying just becomes so much more rewarding. And finally, in the 2 final minutes, I just briefly want to mention some remedies. I want to keep that brief because that's not the focus of the paper. The focus of the paper is to shift the attention from thinking of the market as something that is just there, and antitrust something that counteracts it, to, well, a perspective that understands market concentration, especially online, as a property regime dysfunction, as an internal dysfunction. Remedies, I think, can be grouped in sort of several buckets. The first bucket that directly relates to the analysis here is to say, well, if property rights and the extent to which they allow the internalization of externalities are the problem, well, then we need to rein in those property rights. So what's one possibility? Well, we could limit the ways in which platforms can use their terms of service to exclude others. One example. We could further rein in the protections that the CFAA grants. Maybe we don't need criminal penalties that might be over-enforcing this protection against hackers. Maybe we can scale it back to civil liability, right? There's a lot to tinker with. Second, we can expand and create digital commons. Digital commons basically being the opposite of privatized platforms. One way to create digital commons are interoperability rules. Interoperability rules being rules that allow, enable competitors to connect with existing incumbents, to connect with their networks. If we do that, well, then we change the aggregation of network effects from the level of the firm to the level of the market, potentially, depending on how we structure them, to the level of society. And third, for the remaining entitlements, for the remaining individual entitlements, we might want to rethink their structure, and we might want to push their structure from mostly being focused on exclusion to regimes that place a larger emphasis on liability instead. Just to give one example, maybe we shouldn't give injunctive relief where competitors and or users have violated terms of service. Maybe we should only and exclusively award damages. And we can apply similar thinking to Section 230 and potentially to the CFAA and so on. So with that, I'm very excited to hear any thoughts or feedback. I'm very happy to answer any questions. And most importantly, thank you so much.
Thanks for your wonderful speech. And my question may be a bit outside the central topic. Actually, I found your argument quite convincing. However, there always be some kind of past dependence in the action of the legislation or the regulation or even the judicial practice. Not to mention the big tech will try their best to resist these kind of changes that you are arguing for. So my question is, in your view, in what ways can such a kind of paradigm shift in the public mindset can be accomplished? Thank you.
Okay. So what is the political climate that we would need, or the political economy that we would need, that any of those remedies could be put into action? Is that correct? Okay. So my pessimistic view is that at the federal level, I don't see any of that happening within this administration. There is some, I think, glimmer of hope left in with respect to the FTC. This is because the FTC has, while the FTC has rolled back some of the pro-competitive initiatives, it has not rolled them back completely. It has, I would say, if you want to give it a positive spin, targeted them. It has targeted them to issues of current concern of the administration. And so to the extent that competition concerns that I've articulated align with issues of concern to the current administration, I think the FTC is definitely willing to pursue to pursue some pro-competitive remedies. That is one bucket for the FTC. The other bucket of the FTC's potential actions is that the FTC has, even where it doesn't have a sort of a hot button issue to care about, has not rolled things back completely. The rule on non-competes is an example. The FTC under the Biden administration came out with a blanket ban. The current FTC is walking that blanket ban back, is no longer defending it in court. However, is also not completely giving up on the enforcement actions against companies that use non-competes. So just recently they came out with some letters to companies where they think that companies have gone too far. So bucket one is there are priorities that the current administration has where I still see pro-competitive action. Two, even where they don't have a specific hot button issue to care about, they have not completely walked back things. Beyond that, I don't see much happening at the federal level. Why might there be change at the federal level? And I think the most interesting thing to speculate about is what impact has the great power competition with China on the competition policy that the United States will pursue internally. And there are basically two ways. One way is to say, because the United States is in a great power competition with China, the United States needs to internalize, accelerate competition. Why? Because competition is what creates innovation, and innovation is what you need if you want to win the AI race. Here's the other spinning of the story, that is, the United States is in great power competition with China. If it wants to prevail, it needs huge national champions. And how do we get huge national champions? That is by letting them alone, letting them accumulate the type of capital that they need, and letting them innovate. I think both of those are possible. It seems as if, but I might be interpreting too much, it seems as if the current administration has for now settled on the latter, meaning leaving them alone and saying national big champions are the way to go. But I'm not sure whether that is, one, sustainable, and two, whether that is supported by the base of the current administration. So what's left beyond the federal level? And that's the states. The states are left, the states are active, the states, I think, will become more active over the next, 3 years of this administration. It's ambitious state AGs. It's states that want to position their governor potentially as a viable candidate for the presidency in 28. Wink, wink, Newsom. If he gets over his domestic sort of pro-incumbent supporter base. Do you want to? Shall I?
You should.
Oh, no, go ahead. I don't want to.
No, usually I do let.
Okay. We'll just go this way around. Okay, yes.
Hi, thanks so much. Super interesting. So I have one question about kind of the terms of analysis and another question about how things or how you see things changing recently. So I was curious to hear more about modularity, and because to me it maybe seems that it's incidental rather than essential, right? That something is more easily property when it is modular and removable from a system, and that property does not make the thing so. So just wanted you to explain that a little bit more. And then I'm just wondering, you describe the whole sort of legal regime. Are IP rights becoming perhaps less important, and maybe things like infrastructure, data centers much more important in the age of Gen AI? Because that also creates a set of property concerns, not quite the ones that you laid out here, but that seems like another important factor.
On the latter, I think I agree. So maybe I should have 6 fences, where the 6 fences, the property rights in data infrastructure or so. Maybe, good point. I'm already at the upper word limit for submission, so I have to suggest which other part I take out. But that is very fair. Maybe some explanation on the essential functions of property are too much in there. I don't know. But that's a very good point. So I fully agree. On the other part on modularity, I think what I want to point out is sort of the other direction, is not necessarily how do we identify property? Well, because it enables modularity. It's that property as a regime is what enables modularity. So it's not how do I identify what is property? It's like, if I have a property regime, then I choose that mode of operation, that tool, because it is essential to creating modularity. There is just no real other way to do it, again, in a positive transaction cost world.
Okay.
If we lived in a negative transaction cost world, and in a zero transaction cost world, negative would be amazing, huh? We'd be trading ourselves rich. In a zero transaction cost world, then you could do it differently, right? You could, one, do it through contract, and two, which I didn't mention earlier, you could also by law define tiny individual chunks and modules. You know, if it were free to engage in that endeavor, you could design, socially plan, centrally plan all those tiny individual relationships. Yes.
Thanks for your talk, Nick, and it's wonderful to have you back. I guess I wanted to ask if the concept of data trusts, which has been, it's been discussed but not really mainstream, like, does it speak to some of the remedies? Because across the world also, like, I can talk about it in a transportation data context where, some local governments are entering into data trusts with the big companies to share data for public good. But somehow that has not lifted off. And I was wondering, as in, aside from the regulatory incentives, is it because there are, is it because there's no regulatory backing, or are there like deeper reasons behind the mainstreaming of that? Is it something that you think is, the US would consider it? I don't know if it's happening right now.
No, again, so yes, one could build out the remedies and could say, well, one of the important commons that we want to build are data commons, right? So instead of saying interconnection commons, we build data commons. So there are a few reasons maybe why I didn't include data commons here. One, so my analysis, rightly or wrongly, do you tell me, rests on the assessment that what creates the monopolies, first and foremost, is the aggregation of the value of connections. And now, yes, there is a mutually reinforcing mechanism between the value of connections and data that is sort of well explored. I just didn't focus on the characteristics of data as the main driver of monopoly. One could, and people have made that argument a long time ago. I think it was Yale Law Journal publishing something around essential data or so, where the argument is exactly that underlies data. There is an argument to be made that moving towards AI and holistically embracing AI may maybe counterintuitively loosen the direct dependence on data. That is because, so if you believe the claims that you can synthetically generate new outputs and then train algorithms on that, then maybe potentially the direct access to the original data is not as important anymore as it was. Who knows? I can't tell you whether that's actually true. That's some arguments that have been made. Then why didn't I focus on it? I think the idea of data trusts as explored on the more local level was Canada, right? Or what was it?
Canada, India, very few examples, yeah.
Like, if we already have doubts about the political feasibility of interconnection, I think data trusts are definitely not going to happen. The Google remedies now in Google search have elements of data sharing, which might not be the same as a data trust, because usually I think a data trust is associated with entity that runs that and not just data sharing. So it has some elements of data trust, but I mean, they're at a laughable level. They're not gonna go anywhere. So yes, I think one could include it as a remedy, but I'm not sure whether it's a remedy that would directly speak to the core problem that I identified above. Okay, I think you were next, and then with, yes, Jimmy.
Thanks, Nick. I'd be curious to hear more about your view on the negative externalities story. So, like, you explain well how they're able to internalize the positive externalities, make the money, etc. But there are like two extreme versions of the negative externalities story to be told, right? One is, and this is bad because there are all these negative externalities, privacy, mental health, etc., that they don't need to internalize because the law is as it is. But the other extreme would be to say, But actually, the current system makes them internalize these externalities quite well, right? Like this is the logic behind the Apple Store decision, saying yes, this is a monopoly, and yes, maybe we're losing something, but the gain we get from the fact that Apple pays so much attention to security of the apps it runs on its store is worth it, right? So that like the overall benefit analysis is worth it, and that's usually the major critique towards all the interoperability proposals. So I'm just curious to know what do you think on the balance of positive and negative?
Okay, so balance and positive, negative. So first of all, I think your one point about should one focus more about the negative and externalities that do not get internalized? Yes, I think that's just something I have decided not to focus on. But Section 230 is like the classic example of a provision that allows you to fully internalize positive externalities while almost fully externalizing, almost fully, not entirely, but almost fully externalizing negative externalities. So yes, one could first bring up these negative externalities as sort of a supportive argument and say, actually, what these legal norms fencing in digital platforms do is they're who's a chemist? What are those membranes that allow stuff to go into one direction but not the other ones? Semi, yes, thank you. That was the word I was looking for. So in a sense, those fences are like those membranes, right? They let positive externalities in. Well, I guess it's not the other direction. Maybe bad image. But like they only let certain things in, but not the others, right? They only let positive externalities in, but not necessarily others. It's very true for Section 230. It's not necessarily true for all the rest. And that is maybe the transition to your next, to your other point, namely that the management also, enabling them to manage whole systems also internalizes negative externalities to some extent. So maybe 2 points to that. So I think in this overall cost benefit analysis, at least what I've been focusing on is the impact it has on property's functions that property plays in society at large. And even if we assume that the cost benefit analysis as it relates specifically to externalities might be one that we deem good, right? Well, your argument. Even then it would still undermine the other two functions. The function of enabling liberty, definitely. I mean, there's still monopolies and still undermine liberty. And the argument about modularity as well. And now the balancing that we would need to engage in is to say, well, is the internalization of those positive externalities worth the damage to liberty and by extension democracy, and the damage done to modularity, and by extension the decentralized aggregation of information aggregation. Yeah, open question. I can't quantify it for you. I have 1 point to add, which is to say that I think specifically in this trade-off between privacy and monopoly, or between privacy and antitrust enforcement, I have just started working on a project that might speak to this slightly. Is that I think it's oftentimes missed is that this privacy safeguarding that they to some extent engage in comes at a huge cost to power asymmetries. And if you understand privacy not just as secrecy, as in keeping information where it is, but as more holistically enabling certain types of privacy harms mitigated by power asymmetries, a reduction in power would, to at least significant extent, also support privacy in and of itself. Yes. And yes, and then Dave.
So really appreciated this. I guess I have a question where even if there are sort of certain interoperability remedies, the incumbent is likely going to retain some sort of infrastructural power over product development, over whatever else. And I guess, and maybe that retained power still poses problems for liberty and democracy and whatever else. And maybe an example that doesn't perfectly illustrate this, but is somewhat close, is Chromium, where it's on a network, but it's a public good that benefits from network effects. And despite people using it and benefiting from it in the market, benefiting from Chromium being open source, Google, through its governance power over it, still can shape web standards and whatever else. And I guess my question is is that setup sort of good enough? Or do you think that not only should the benefits of the public good or the network be aggregated to the market, but there should be governance power that's also disaggregated? And if that's the case, how do you think about those questions of collective or broader governance of these sort of infrastructural public good network things?
Amazing, thank you. And again, I think I agree with the at least implied argument in your question, which is to say that it probably doesn't do the trick to just scale back property rights. So what I'm currently thinking about, or have been trying to do, is rework the remedies section in the paper to be less about policy prescriptions, as in this is what we should do, and change that towards what have we historically done to networks in the past. And the answer to what have we historically done to networks in the past is we have relied on a set of rules drawn from an area that's been traditionally called regulated industries, more recently has been called networks, platforms, and utilities. And those then, that area of law offers tools that go way beyond the things that I have described here. They include governance prescriptions, they include functional separation along industrial functions. They include duties to deal, and they include the whole package. And so one of my thoughts was to replace this rather narrow set of remedies prescriptions with a more historical account of what have we done in the past to similar arrangements, infrastructural networks, and to what extent has that worked? But again, like I'm struggling with words at this point. Daniel.
Hey, thanks. This is just really a clarificatory question. And could you say a little more about how you understand the role that the concept property plays? Because I can think it goes two different ways. One is the concept is diagnostically useful because it makes it possible to see or to measure certain deformations or harms that without the concept aren't visible. And the second is rather that the concept is more critically useful in that the structure of your argument really is don't let the legitimation story of property count against reforms. So it's not that you need the concept to identify the harms. You can identify the harms just fine without it. But there's this underlying thought that, well, these guys own this stuff. And therefore the reforms face some justificatory hurdle that they wouldn't face if the guys didn't own this stuff. And what you're really trying to say is, well, really, they don't own this stuff because the way in which they assert their power undermines the normative validity of the ownership concept. I think it's the second, not the first, but I'm not sure, and I wanted you to say a little more about it.
It is the second. Emotionally, definitely it is the second, but apparently the text and or presentation haven't conveyed that emotion fully. So yes, the real motivation, core motivation of engaging with this has been this argument that there are network effects and thus we have the digital monopolies. Some have called them natural monopolies even. And then many, if not most commentators that rely on antitrust, they implicitly follow this logic. They say, well, there is something and now we need to have a really thorough justification why we interfere with this arrangement that we have just normalized. So yes, it is definitely the second one. To the extent that some of my presentation or some parts of the papers appear or read as if it was the diagnostic tool, I think I might have fallen into the trap of wanting to justify why I call platforms property, even though one, it is just not property in the traditional sense, and two, it raises some issues and unintended consequences that I don't want to raise, including constitutional protection, which by calling it property, I then sort of almost make it worse because I say, well, yes, and it's protected, and you can't actually do the remedies that I'm suggesting. So to the extent that it is diagnostic, I am using property just as a tool that enables you to do certain things, namely enhancing liberty, creating modularity, and so on. But not, I don't want to diagnose capital P property anywhere. I hope that, but yes, it is. So it's definitely the second one. Yes. Oh, so I'm sorry.
Well, my question is parallel to Daniel's. I was also.
So it was a two-finger. Perfect. I saw that.
I was also interested in the lack of almost like formal argumentation about property in the piece. So your intuition that you start from very strongly is that they don't own these things. That they don't own the network effects. And I'm curious what the source of that intuition is, because when you think about things like the doctrine of accession in property, right? Or the very like if a calf or a cow gives birth to a calf, you own the calf. And then the understanding that from Locke that if you mix your labor with, or in this case, if you create the connection, you ought to be entitled to the value of the connection could very easily lead to the opposite intuition. And so the two things that I heard that could explain the distinct intuition here are either the nonlinearity of the effects, or perhaps the fact that the value of a connection is in large part generated not by the connector, but also by like the dialogue between A and B who are connected. And I'm curious which of those, or is it something else that does work for you that creates your opposite intuition?
So for me, it's mostly the second, namely that actually we have structures here where it's absolutely unclear who the originator of that value is, if you want to follow labor theory. This is maybe something I need to make explicit, but the intention of the language example was to showcase that English is a network, and we all put labor into that network. Nobody on earth would deduce from that because, I don't know, I created a weird sentence, that this creation of the new weird sentence should, if it were ever adopted, be attributed to me in a sense that I should reap all future benefits. So the intuition, it's possible, right, to get to your point of the fruit, or like considering this the fruit of platform labor. But I just like as a starting point, I have never considered that to be, how should I say, the only possible explanation. And in a world in which there are plenty of possible explanations, I did, without properly disclosing, I suppose, settle on a different one. But yes, so let me think. So I definitely need to make it explicit. I'm not sure whether. So the difference to the situation with the calf is maybe that we don't have those rules, right, for connections.
Yeah.
So I mean, it might go both ways in a sense that we have those rules that extend property in insular areas where we do want to extend property, and most of the time we don't. But that's maybe not satisfying as
one thing that might tie with what you're already trying to do to your remedy section by making it more historical about what have we done with regulated industries before is to see if there have been historical takings clause challenges to, or due process deprivation of property challenges to the reallocating of network effects. And if those were rejected, what rationales did the court use to say you are not entitled to these? And that would honestly give you like a backwards look into what are the justification, like why is this not property in the traditional sense? Why do we not apply the doctrine of accession or the Lockean traditional view of it?
Amazing, wonderful. So there have been plenty of taking cases in regulated industries. However, the ones that come to mind, most of them directly speak to one specific subset, that's rate regulation. And so in those takings cases, the question was then always, is the rate set in a way that amounts to a taking of the substance? I'm not aware, but yes, I should look. I'm not aware of, at least not at the top of my head, not aware of cases where where courts discuss the overall application of a regulated industries regime as the taking in and of itself. It was always these individual clauses or individual limitations, and most of them, my recollection, are price regulation. Yes. Oh, I'm sorry. Please, yes.
Yeah, thank you. I'm not sure whether I understood your point on modularity.
Sorry, can you?
The point on modularity as a feature of law of property. So I would have thought that modularity is the idea that we have standardized sets of duties and privileges and rights, and that we can combine them in various ways. And this is like one great feature about property. And so you say this is a feature that this kind of platform property lacks, but I'm like, and maybe it does. So maybe they are using non-standardized forms to build up their like huge property thing, or like platform itself, if you consider that this like as a property as property as such is doesn't have this feature. But what follows from that, like I'm not sure whether I understand the normative claim that this is bad that I sensed in your argument there, because like you would think, okay, well then they can't combine what they have built with something else, and this is about it.
Yeah. Okay. So so on modularity, so the way that property law is usually or is understood to create modularity is one, through its very strict rules, the numerous clauses, and so we restrict basically the interfaces that individuals can build and the rules that individuals can apply. And why do we do that? So that, well, the whole structure becomes modular, that we can aggregate things, that we can build the world together, just like we build building blocks on top of each other, and maybe more importantly, that we can take the world apart by removing individual building blocks without the whole structure. Now, in brackets, that would be a contractual structure collapsing. The consequence and the advantage is an information efficiency advantage. It is, if you want to change the muffler on your car, you actually do not need to understand the engine. That makes the interaction with the car more information efficient. Same with the wheels. If you change the wheels, you don't need to understand the windshield wiper and how it works. It makes the interaction with the car more information efficient. And so the argument about platforms then is, if I aggregate everything into one huge blob, and everybody outside of that blob needs to interact with the whole blob, instead of being able to interact with individual building blocks, chunks, as it's usually called in property theory, individual chunks, that makes the interaction less information efficient. So interacting with the blob requires understanding the whole blob. Interacting with one chunk of the blob requires only understanding that very tiny small blob. That is not to say that modularity or modular structures do not come at a cost. They do. They come at a cost. They come at the cost of delineating those individual structures, and they may come at the cost of preventing some economies of scale. Undoubtedly, they come at a cost. The general property conclusion has been that these costs are outweighed by the benefits. By the benefits it creates in terms of information efficiency, and this directly relates to the platforms, by enhancing the resilience of the overall system. And we can make sort of a physical property argument, as in, well, if I can interact with just the wheels of the car, then what I'm doing, like the structure remains much more resilient, as compared to a situation in which I have to consider all the potential relations within the car. And we can make that same argument and apply it to the internet. The reason why the internet, the whole, not the platforms, the whole internet is so resilient is because it is built in a modular structure. Because information can be routed anyway. If one connection breaks down, then there are plenty of other ways, at least in most countries. It's not true in all countries, but in most countries, there are plenty of other routes that the information can take. If I now replace that modular structure with a big blob, then if that big blob fails, everything goes dark. And we've seen that happen in platform markets. Facebook went down, the communication in the whole world went down. This little tiny company, what was it? Was it CrowdStrike, that just updated one of their features, grounded thousands of flights in the United States. Why? Well, because that is a structure that is not modular. That is not modular. It was not possible to just plug in and out this update. This update basically had ripple effects throughout the entire structure.
With that, thank you so much for this wonderful beginning to the series. It's great to have you back. Thank you all for the great.